Good evening to all the participants, those who are aspirants of the All India Bar Examination, 17th Cohort 2022. And today that I am going to deal the two acts that is said to be the number one, Negotiable Instrument Act, another is the Property Act. That is the property law. Now let us see some of the questions in the property law first. First question. Number one, what is property? What is property? And here the option which I have given is property. Yes, property implies a bundle of rights over a thing. Number two, the scope of such right is variable. And three, can extend to including the everyone else. Four, from interfering with his enjoyment of that thing. So which one among them is false? One is false. What is that one?
Third one, sir.
Can
Third
extend to including everyone else. Can extend to excluding everyone else. These are right. But I intentionally put including instead of excluding. So third one is the false one. You are right. Yes. Can anyone unmute and read the second question?
Second question. Property includes every possible interest a person can take in a thing, and hence not only includes first one, trademarks and copyrights. Second one, but also patents, and third one, personal rights such as debts. Fourth one, all of the above.
Which one is the right answer? Trademarks and copyrights, yes, it's the property. Patents, yes, it's property. Personal rights such as debts. If the debts cannot be claimed, it can be claimed. Is it not a property? It is a property.
Yes, sir. All of them.
All of them is the right answer. So each one you can take in that way by following either a deductive method or following the inductive method. Third question. Transfer of property takes place when a living person conveys, number one, some property to some other person, or number two, even to himself immediately or at the same time in the past. And fourth one, such a living persons may also be companies or any kind of association of individuals. Transfer of property take place when a living person conveys. One is wrong here. One is wrong here. One is false. One is false. What is that false? Yes. One is false. What is the one?
The second one, sir.
Even to himself immediately. Yes. See, actually, at some time in future, that is the third one, wrong. Third one, at some time in the future, is the right way of saying, but I said, instead of future, I put the past, sometime in the past. So, which is a false one, but other things are very much relevant to the third question. Now, the fourth question is, any transfer of property by such ostensible owner is, number one, voidable. Number two, merely on the ground that he was not entitled to make such a transfer. Third, if the transferor has acted in a good faith. And fourth, taken a reasonable care to ascertain the status of transferor. Any transfer of property by such ostensible owner is, one is wrong here. One is wrong, one is false. Odd man out. One is wrong, that is odd man out. What is that?
First one.
First one is, it is not voidable. Actually, right answer is not voidable. But I put voidable. That means one is not connected, wrong. So not paidable is the right one. Other are very much clearly connected to the Ashram's owner. Like Ashram's owner is merely on the ground that he was not entitled to make such transfer. If the transferee had acted in good faith and taken a reasonable care to sustain the status of the transferor. I did not ask you the supplementary question. Ashram's owner comes under which section of the Transfer of Property Act? Supplementary question. At that instance that you have to try to look at who is the responsible owner. His apparent owner, of course. It's not voidable. No. He can act as a owner because some other factors are there and hence he can be treated as. So now the sixth question. Anyone can unmute and read? No, fifth question we did not read. Fifth question. Anyone can unmute and read. I say fifth question. Here I highlighted.
Okay. Fifth question. Dash refers to the transfer of ownership in exchange for a price paid or promised to be paid at a future date, or a part of the price is paid immediately with the remaining promise to be paid by a particular date in future. First one is sell, second one is sale, third one is exchange, fourth one is barter. That one is first one, sir, I think. Sell, S-C-L-L.
Wrong.
Correct. Why? Because sale is done, sir, actually. But here you are talking about future payment also. Then it's
Yes. Part payment now we
S-C-L-L.
can make it out. Part payment future also we can make it out.
Yes, sell, S-C-L-L.
Sale. Number 2 is the answer. S-A-L is sale. Sale refers to the transfer of ownership in exchange for a price paid or promised to be paid at a future date, or a part of the price is paid immediately with the remaining promise to be paid in particular date in the future. But price is there, but not any other thing. That is a sale. So sixth question. In case of sale, the buyer dash becomes the owner of the property, but this is not so in the case of the hire purchase agreement. So what is the dash? Number 1, after the second day of the sale. Number 2, immediately. Number 3, after 1 week later. Number 4, none of the above.
Fourth, sir.
Wrong.
None of the above, sir. Why? Because after the payment, the second payment only will become the owner actually. None of the above.
In the sale, either you pay partly or you pay full, or you pay
Yes.
partly and or you pay the future, because price is there immediately. Second is the right answer. In the case of sale, the buyer immediately becomes the owner of the property, but this is not so in the case of hire purchase agreement. Supplementary question. Hire purchase agreement, the papers are with the bank, and the only position will be given to the person who applied for the hire purchase. And once all the payments are made, then bank will transfer the ownership on the name of the buyer.
Right.
Is it clear?
Yes,
Yes, sir.
yes.
In hire purchase, the purchased person is not the owner of the property unless until he clears all the premiums. Okay, now next question. Seventh question. If money is lent by a lender to a borrower backed by a security, the lender will be protected as even if the borrower becomes insolvent. The security is given precedence over the other creditors under which caption? Number 1, hire purchase. Number 2, exchange. Number 3, gift. Number 4, mortgage.
Number 1 is correct, sir.
In hire purchase, he is not the owner of the property. He is merely the possessor of the property. Who becomes insolvent here? Borrower becomes insolvent. The security is given precedence over the other creditors, under which caption the right answer is
One.
mortgage. The right answer is mortgage. Is it clear? In exchange, you exchange one to another, no price. In gift, where there is a relation should be there, a close relations, and it will be given without consideration. But the consideration is, what is the consideration in the gift? If you don't know, you say pass on. What is the consideration in the gift? Love and affection. Anyone can unmute and read the 8th question? Anyone can unmute and read the 8th question?
Eighth question, the person who transfers the interest is called the mortgagee, mortgager, vendor, vendee. Sir, answer is vendor. Third option.
Wrong. Do you know what is meant by vendor? A person who sells the goods is called a vendor. At that instant, the person who transfers the interest is called. See somebody. Please mute. I'm getting the sound. See, whenever is speaking. Parshuram.
Sir.
Mute.
Okay, sir.
I am getting the sound.
Okay, sir. Sorry, sir.
Mute. Still you did not do it.
Okay.
Still you did not do it. Yes, now you did. No. You mute it. I am getting the result.
Okay, sir.
Do you know how to mute out? Unmute? There are two buttons are there.
Yes, sir.
Press the button. Mute button. Just touch the mute button enough. No. Still you did not do it. I am getting the resound. Because my sound will be heard to me only. Okay, let me try from my side. I will try to mute it. Mute all. Okay, I muted from my side. Okay, when you speak at the time, you unmute it. When you don't want to speak, you mute it, because from your side, I am getting the sound. Okay, now let us come to the next question. So here the mortgage is the right answer for the 7th question. Because a person who transfers the interest is called, it is also here, it is the mortgage. Mortgager, he transferred the interest. But he did not transfer the ownership. The 8th question. The person who transferred the interest only, but not the ownership, is called the mortgager. And the person who receives the property is called a mortgagee. But the vendor, a person who sells the goods, is called vendor. A person who purchases the goods is called vendee. Is it clear? Say yes.
Yes, sir.
Good. The 8th question, right answer is?
Mortgager.
Mortgager. That is the second option.
True.
Right. Anyone can unmute and read?
Ninth question. A can be enforced against a bona fide purchaser for value, whether with or without notice, but A cannot.
Parshuram, again you open it.
Mute kara na.
From your side, I am getting the resound.
Option 1, charge and mortgage. Second, mortgage and charge. Third, mortgage and mortgagee. Fourth, mortgagee and mortgage.
Which is the correct answer? Yes. Shoot, even though it is not a negative marks are there. Shoot. There are no negative marks. The answer is the second one. A mortgage can be enforced against a bona fide purchaser for the value whether the or without the notice, but cannot charge. There is the second option for the ninth question. Is it clear? Say yes. Is it clear?
Yes, sir.
Very good, very good. 10th question. In dash, the property is not transferred by way of security for the payment of money borrowed. Number 1, mortgage. Number 2, lease. Number 3, charge. Number 4, exchange. Yes. Try to shoot it. There is no negative marks.
Number 1.
Wrong.
Number 3, sir, then.
Wrong. Number 2, lease. In lease, the property is not transferred by way of security for the payment of money borrowed. So, 11th question. The mortgagee may retain possession of the mortgaged property and receives and apply the rents and profits made available from the property during the same time towards the satisfaction of the debt. He is entitled to retain the such possession until the complete payment of the mortgage money. Such transaction is called a dash. A simple mortgage. 2, beneficial mortgage. 3, conditional mortgage. 4, usufructuary mortgage.
4.
It is the usufructuary mortgage where he could enjoy the benefits till the debt amount is paid back to him with the interest. Of course, I don't think that they take the interest also because he's enjoying the usufruct. So, 12th question. The right of dash signifies the inherent right of the mortgager to get back his property and documents on payment of the mortgage money on or before a specified date. What is comes under dash, right? Appropriate word. Number 1, redemption. Number 2, assumption. Number 3, presumption. Number 4, rescission.
Number 1.
Number?
Number 1, redemption.
It is the redemption is the right answer. The right of redemption signifies the inherent right of the mortgager to get back his property and document on payment of the mortgage money on or before a specified date. So the right of the redemption signifies the inherent right of the mortgager to get back his property and document on payment of the mortgage money or on before a specified date is the feedback. 13th question. Anyone can unmute and read. 13th question. Anyone can unmute and read.
When the mortgagee files a suit to prohibit the mortgager from exercising any right whatsoever in relation to the property, including the right to return, it is known as a suit for 1. Redemption, 2nd. Foreclosure, 3rd. Doctrine of frustration, 4th. Unfractionation mortgage.
Usufruct mortgage.
Number 2.
Sir.
Answer is foreclosure it is. That is known as a suit for the foreclosure. The definition of the foreclosure they have given over there and made the 4 options and one is correct. 14th question. A tenancy at will cannot be dash.
Number 2 is a foreclosure, sir. 2 is
Yes.
correct. Number 2 is correct. Foreclosure.
Yes, I am speaking. Number 2 is correct.
Yes, sir. Yes, sir.
13th question. Number 2 is correct answer. Now, shall I proceed?
Yes, sir. Yes, sir.
Good. 14th question. A tenancy at will cannot be dash. The landlord must give a reasonable notice asking the tenant to quit. Number 1, eliminated. Number 2, waived. Number 3, alienated. Number 4, avoided.
Alienated, sir.
It is alienated is the appropriate word. A tenancy at will cannot be alienated. The landlord must give reasonable notice asking the tenant to quit. 15th question. Anyone can unmute and read. Anyone can unmute and read. 15th question, which I highlighted here.
15th
Sir,
question.
when
Two
two-
persons mutually transfer the ownership of one thing for the ownership of another. Neither thing or both things being money. The transaction is called option 1 mortgage, option 2 charge, option 3 lease, option 4 an exchange.
Number 4. Number 4, exchange.
You are
Option
right.
4 exchange.
It is an exchange. When two persons mutually transfer the ownership of one thing for the other ownership of another, neither things nor both the things being money, the transaction is called an exchange. Yes, 16th question. Anyone can unmute and read. Sixteenth question. Anyone can unmute and read.
16th question. What are the types of negotiable instruments? Common ones include, but one does not belongs among 4. First one, personal checks and travelers checks. Second one, promissory notes. Third one, certificates of debt orders. Fourth one, money orders. I think the fourth ones are money orders.
No, it is a negotiable instrument.
Third one, sir, certificates of debited orders.
Certificates of not debited orders. It is a certificate of deposit.
Okay.
Certificate of deposit, you should say. See,
So
personal
personal
checks,
checks,
you know, the check
wrong.
CHECKS wrong. It is not the check right spelling.
CHEQES.
CHEQUE is the right spelling.
Yes.
I don't know why the people will write in this way. Checks. CHEQUES. Checks. That is the proper way. Okay, now auto save. Yes, auto save. You have to save it. Right. Next, 17th question. Which one is correct statement? Number 1. The most important feature of negotiable instrument is the accumulation of the primary contracts as they are transferred from one person to another. Second option. The most important feature of negotiable instrument is the compilation of a secondary contract as they are transferred from one person to another. The third option. The most important feature of the negotiable instrument is the accumulation of the secondary contracts as they are transferred from one person to another. The fourth option. The most important feature of the negotiable instrument is the accumulation of the secondary contracts as they are shifted from one person to another. So, which one is the correct statement among the 4? Only one is the correct statement. All other 3 are the wrong statements. Now you tell me which one is what.
Option 3, sir.
Option 3 is the correct statement.
Number
Number 1 is wrong. Number 2 is wrong. Number 4 is wrong. The third option is the exact statement. The most important feature of the negotiable instrument is the accumulation of the secondary contracts as they are transferred from the one person to another person. Appreciate. Which one is not acceptable statement? Number one, the drawer of the check can cross the check generally or specially. Number two, it is an open check, then the holder can cross the check generally or specially. Number three, option, if it is an open check, that the holder cannot cross the check generally or specially. The fourth option, if the check is crossed generally, the holder can cross it specially. Not accepted means wrong.
Number 3.
Number 3 is the wrong. If it is an open check, then the holder can cross the check generally or specially. See, if you closely look at it, which is the right terminology, you can make it out. And sometimes not will be removed, sometimes not can be added. So both the way it can be done, but use your logic, then you have to try to make it out. And here I did not ask any sections. But if you say the Transfer of Property Act is applicable to whom? Christians, Muslims, Jains, Hindus. The provisions of the Transfer of Property Act. It is especially one section is there, if I not be mistaken, 69th section of the TP Act.
Some sections are not applicable to Muslims.
Muslims, it will not be applicable. For other people, yes, they can come under the Transfer of Property Act. In the Transfer of Property Act, what are the 5 or 6 components are there? Where the exchange is, where the a property can be transferred. Number 1, mortgage. Number 2, exchange. Number 3, lease. Number 4, can the gift come under it? Answer is yes. Exchange. Next is, can the will come under it? In the Transfer of Property Act.
No, sir. No, sir. No, sir.
Will is a separate. Will is a separate. And which act will deals the will? Which act deals with the will?
Indian Succession Act
Indian Succession Act
1925.
will deal the will. Whether it is applicable to the Jews and Christians, Muslims and Hindus.
Christians.
For the interstate or for states.
Muslims are not applicable, sir.
Then what about the Christians?
Christians applicable, I think.
So you check
Sir, it's Indian succession, it
how it
comes
can
for
be applicable
Christians.
and when it cannot be applicable.
For some Christians, it is applicable like that it is there. Some Indian Christians like
Yeah,
that.
because you say the Goa, there is a separate is there, something. Even Goa and Dayu Daman, you check it, no, it will not applicable. They do have their own customary way of the dealing the property. But in Pondicherry, I believe that the French Common Code will work over there. Please you go through it so that you could have the supplementary questions. And here I will make the negotiable instrument. Which sections, major cases will be filed under the Negotiable Instrument Act? Anyone?
Section
Checks,
138.
Checks. 13. Checks only. 138 negotiable. NI, sir.
What it says about? What it says about?
Dishonored checks, sir.
Repeat.
Dishonored checks.
Dishonor checks. What is the another terminology for the dishonor checks?
Check bonds.
Check bounce. Appreciate. And what is the new law is there? Because now they are making whether the check bounce is a criminal offense, civil offense, ethical offense, or all of the above?
Criminal offense, sir.
It is a criminal offense.
Criminal offense.
Of course, still they want to make it a stringent, but the people say no. Intentionally, if he has given over there, then we can make it out. Otherwise, we cannot make it out because half of the amount will be paid before you are claiming the suit. If you are defending the suit, half of the amount you have to go deposit in the court. Of course, the new amendment is not still in, the rules are not framed. That's why it's not going to be implemented. Otherwise, it will be a string because most of the people are doing intentionally because it takes its time and the court will give the order, okay, you pay in the regular installment with the interest. Are you following me? Because they know it,
Yes, sir.
it takes at least 2 years. By the time we can manage it. So now, negotiable instrument is a piece of paper which a entity is a person of sum of money and a piece is transferable from person to person by mere delivery, by the endorsement and delivery. Suppose if I ask the question, here I can frame it. Negotiable instrument is a dash. I say piece of paper. I'll say a document of paper. I say a legal document. I'd say a promissory paper. So which is the appropriate word? We can make it out. So when you read it, see that what is the possibility would be there to change it. The negotiable instrument plays a major role in the trade world. I can frame the question. The negotiable instrument plays a major role, dash, in the trade world, in the market, in the business, and none of the above, we can make it out. So right approach is in the trade world, negotiable. So the maximum of the this I can ask the maximum also important because the maximum of law, nemo dat quod non habet. No one can transfer a better title than himself has. This maxim, where it can be applicable? Number 1, Transfer of Property Act. Number 2, Negotiable Instrument Act. I did
Transfer
not
of
ask-
property.
Transfer of property.
Transfer of property, sale of goods.
Even sale of goods also there. Yes. It can be not. Even in tort law also we can file it. No one can be enriched himself at the cost of others. So I did not ask you the Transfer of Property Act, which year and what is the act number? Transfer of Property Act, which year? Anyone? Sir, we did not see it.
1889, sir.
I think you are right. 1889 or 1886. Let me check it. Because why the doubt is there. So, Transfer Property Act here. We can know that because that is a technical question. There probability would be there. I did not cover it. Transfer of Property Act. Which year? 1882.
82, sir.
Not 1886, 1889. Transfer of Property Act 1882 is an Indian legislation which regulates the transfer of the property in India. What is the act number? Of course, we have to see the bare act can be given. Okay, enacted 17th February 1882. Commenced 1st July. Supplementary questions I am framing. When it is enacted and when it is commenced. That is commenced, it is 1st July 1882. What is the act number? We have to see the bare act. What are the foreign definition of the character of the? We have to, if you see the bare act, this is a bare act.
Number
The
4.
bare act, I think it is the act number 4 of 1882. Yeah, here it is given. Act number 4 of 1882. So how many chapters are there? Supplementary question. If you see the chapter supplementary question, of course schedules, whether schedules are there in the Transfer of Property Act. Chapter 8 is the last because it is showing, but here the table are given. If the schedules are A, statutes, schedule. And the schedule is given. Of course, statutes, the B is, one is statutes, then B is regulation, C is regulations. Then what is the question of B? A, statutes. B, acts of the Governor General in Council. So in schedules, A is there, B is there, C is there in schedules. And what is the last section of the Transfer of Property Act? Last section. See, 134 mortgage debt, 135 capital A, because it is inserted later part. It is the assignment of the rights under the policy of marine insurance. So marine insurance will say with the section 135 capital A. Then the last section is 137. That is saving of the negotiable instrument, saving acts. Nothing in the foregoing sections of the chapter applies to the stocks, shares, or debentures. They may ask stocks definition, share definition, debenture definition, and lease definition. In the left hand side, they will keep stock, shares, debenture, lease. In the right hand side, they will give the answers. Match the following from part A, taking from the part B, the explanation. So supplementary question they may ask in that way also. And if you listen my last year, I think I have covered something like part A, part B. And you can see it under the directly on the law of contract or specific. No, yesterday we have seen the specific relief act. I conducted a special session for the specific relief act for the earlier batch people. Even though marks comes only 2 marks from it, but even 1 mark makes the difference. Even 1 mark makes the difference. Thank God you will be blessed. There is no negative marks in that one. If the negative marks would be there, oh, many people will be kufa, means dead. Kufa means dead, die. Because if the negative marks are there. Because he can ask from any corner. And however, even myself also there, sometimes I will be also confused, even though I can make it a lot of efforts and make the software in such a way that I can easily make it out which is the right answer. But still, sometimes, no, if they ask very technically, very near answers, at the time it's difficult to shoot. Our probability is more there, at least 70% to 80% we can shoot it. Because we know that different mechanisms and how a question will be framed and what would be the right answer for that one, and whether he asked which is the correct one, whether he asked which is the false one, or whether he asked the match the following, and we can easily make it out. Suppose in the match the following, I told the technique. If you make it out 2, automatically you can make it out the rest of the 3 and 4 also. Are you following me? But you are two must be correct answer. And the 3 and 4th you can easily make it out because choice will give you a hint to it. Yes, this is the right answer for that question. So supplementary questions are in that way it can be asked. And again, I did not touch the Negotiable Instruments Act because whether it is anybody who is the father of the negotiable instrument or mother of the negotiable instrument, if such a thing is there or not, you try to make it out. To my knowledge, there is no such a thing. But they may ask the thing before the passing of the Transfer of Property Act 1882, which act can be used or which act can be repealed, and how many amendments are there for the the Transfer of Property Act 1882. In the similar manner, they may ask also how many amendments are there in Negotiable Instruments Act. What is the latest amendment year or provisions? Even I am giving a hint to you so that you could keep in your mind the framing of the questions and how it can be made. Are you following me? Anyone can unmute and say yes.
Yes, sir.
Yeah, because there is a long gap is there, I could not get the answer of yes or a response from your side. So that is the way that we can make it out. And of course, jurisdiction, they don't go that much. Which court is having the jurisdiction to entertain the case? Suppose the check is bounced in a different country, different place. So very rare cases would be there where the check bounce cases. Suppose the check is issued in Warangal and it is bounced there in Hyderabad. Which court is having the jurisdiction to entertain the case? Such a thing happened.
Warangal, sir.
A check issued by the which bank? That is more important.
Yes.
And where the cause of action has taken place. The
Taken
cause of
place.
action taken place, the check, it belongs to the which branch? Either branch of Warangal or branch of Hyderabad. If it is the branch of Warangal is there, naturally, the jurisdiction of the check is Warangal or Hanamakunda, and the court which will entertain such a check, that court we can file a case if the check bounces from that place. So anyway, that is a little complicated. I don't think that such a would be asked over there, because if the two countries are there, then I can give the answer for that one, because it's a private international law. And check bounce is a contract, because it is a contract that you are going to pay this much amount to him. And it comes under the, of course, some countries is a negotiable, separate act would be there. But we can bring in an action the place where the plaintiff is feasible to him. So that is the jurisdiction that we will say. And here I did not say, let me check the section 49, I told you, no, 49, 69. 69 is a special provision, I told you. Let me check whether it is there. 69 exactly where it is not applicable to the Muslims. 59 is there, 60 is there. Then we'll see the 63. Then we can scroll 65. Then afterwards, what is that? 64, again renewal. 67, it is come. Yeah. Power of the sale when valid, 69. But there is a subsection 1, 68. That means not the 69 is, I think 49 might be the right answer for that, 49. Because this is the Bear Act which is given in different. Generally the Bear Act, in the Bear Act, no, they will give the first summary. Next, the total details. But here I did not see the summary. In the summary, we can directly go to the section, 49 section or 69 section, we can directly go. But here we cannot go in that manner, because it is given in a different style. So, when you matter comes to the negotiable instrument is concerned, again, in which year it is passed, and negotiable instrument Act of India. The Indian Code Negotiable Instrument Act is 1881, and the long title is an act to define and amend the law relating to the promissory notes, bills of exchange, and checks. Enactment date is 1881, that is the 12th December and the 9th day. That is what is the Negotiable Instrument Act 2018? So is it, which act? It's the Negotiable Instrument Act of 1881, NI Act, came into being an act to define the amend the law relating to the promissory notes, bill of exchange, and checks. That is the long title. And Amendment Act is 2018 is given. What are the provisions of the Negotiable Instrument Act 1881? So they have given how many? In the negotiable instruments, how many type of the instruments are there? Anyone?
It's 5.
What are they?
Basically 3 types, sir.
Yeah, but we can say, because now traveler check is no more now available over there. Only we can say checks. Either it is a checks is a bearer check or a cross check. Whatever the promissory note, yes, promissory note will be taken as a negotiable instrument. Is it or not? Regarding the debts also, we can treat as a negotiable instrument. Debts. Yeah, right, we do have it. So they say section 138, we said the check bounce. But what is 143? Because they have 143 also, 143 capital A of the Amendment Act empowers any court while trying an offense for dishonor of a checks to direct the drawer, who is the issuer of the check, to pay the interim compensation to the complainant. The amount of the compensation payable cannot exceed 20% of the amount stand in the check. But under the amendment, I believe that the amount is increased as far my knowledge goes. But still it is not implemented because rules are not formed over there. So section 143 capital A deposit of this money, the money value of the 20% to the check, which is figured over there in the check bounce. So that is the one of the important one section 143A capital A and 138 the next provision. And we already said section 138 is that dishonorable check, dishonor of the check, that is the check bounce. So here he committed no sooner a check drawn on the accused on account being maintained by him in a bank or discharge, the debt or liability is returned unpaid for the insufficiency of funds for the reason that the amount exceeds the arrangement made with this. So insufficient fund, that is the actual wordings. The offense insufficient fund available in the account, that is the exact wording that you can use it. And when you come to the salient features of the Negotiable Instrument Act, and here they have given writing and signature, negotiable instrument must be written and signed by the parties according to the rules relating to the promissory note, bill of exchange, and checks. It is about the money, negotiability, title, notice, presumption, special procedure, popularity. These are the 9 essentials. If I ask frame the question, one among them is not the essentials of the negotiable instrument, then we can say writing and signature number 1, number 2 is the money, number 3 is, let me scroll down. Why it is not giving? Because here it is clearly mentioned earlier. Yeah, these are the certain Negotiable Instrument Act sections. And we have to frame the questions by reading it and how probability the questions are going to be asked, we can manage it. And that by this, I would like to stop my today's class because the time is now, because we started at the 5:30 local time and 5:30 minutes, 30 minutes and 20 minutes, 6:20. And now the 6:20 still time is there. And but now I covered only this one. So I would like to stop it. The next class tomorrow, we will see what is the next. Say, what is the next?
Land Acquisition Act.
Land Acquisition Act. So please read the provisions of the Land Acquisition Act. And now the last one is intellectual property law. So tomorrow is the Friday. Is it tomorrow is the Friday?
Yes, sir.
Yes, tomorrow is the Friday. So Saturday is the last day. So Friday and Saturday is the last day. So read the Land Acquisition Act tomorrow, and we will work out the day after tomorrow intellectual property laws. With this, I think we have made a little justification. But please go through my earlier questions also, which is there in the.
Sir,
Yep.
sir, is it enough, sir? We can study this, and that will be enough for the AIB to crack.
See, it is very easy to crack because there is no negative marks, provided a person should have a knowledge of it. Just today I question asked, most of the people did not give. Only 2 answers they given. Right way. Foreclosure, right way given. But other thing, mortgagee, this thing, lease, no one has given the right answer except foreclosure. So you have to know the definitions.
Hello, sir. One point, sir.
Yeah, please.
After this completion of classes, better if we solve all the previous about 16 papers, AIBE ka.
Okay.
Whatever the previous papers, if we solve, that is enough along with these classes.
Because what I am trying to
because here you are seeing subject wise, there you will see mixed one, jumbled.
Yes, sir. Yes, sir.
Here you can guess some question based on the subject.
Okay.
There you don't know whether it is from which subject. So that is enough, I think.
See,
Sir, one more question, sir.
yeah, please.
So I'm just about to give this PG law set for LLM.
Okay.
So is it like we can expect some questions from this material, your material, and
Yeah, yeah.
Yes,
Probability is more. Probability
these are
is more.
so useful. Yes.
okay,
See, what I am
okay.
teaching
Two questions
is
will come.
I am
Technically,
framing the
how to
question
solve the
in a
question?
different angles,
Yes, yes.
and that will give the sense to you, even though you don't know the answer exactly, but you can use the technique which I used over there, and you can easily make it out which is the right answer.
Yes, sir. Technically, you're just giving us idea.
Idea, how to
Yes,
fish
yes.
and where to fish. What are the rules of fishing, and can you fish in the troubled water? If once you get an idea, you can fish anywhere in the world.
Okay.
So
Yes,
that
sir.
is the idea which I'm
Oh,
making you.
yes, sir. So one more thing, like as there are JCJ exams, we are about to write in August.
Okay.
So do you help us in uh, giving ideas or
See, the
anything to
JPG
crack
exams,
JCJ?
it's more not theoretical based, it's more practical based.
Yes, yes. First, there will be a prelims, right, sir? We have to
Yeah,
crack the
of course,
prelims.
it is only multiple choice questions.
Yes,
But
sir.
based on like the criminal procedure code, they ask law of evidence, they will ask, and they will ask the civil procedure code, law of limitation, they will ask, and many other, the technical one. So justification will be more given to the person, those who are practicing lawyer, because they know the technicalities, how it
Yes,
can
yes.
be
So
moved.
we can use this technical ideas
Yeah,
line
with technical
there also,
ideas,
right?
we can also get it. What is the procedure would be there, where the case would be filed, and how it can move it, when the case will be numbered, when the summons will be issued, and what order will be filed. So these are the things generally people are supposed to know it. Let us see, because here I am now dealing the two master courses, because of my curiosity would be there to teach the LLB students, and hence I am dealing the LLB students also, and guiding some LLM students for the research. But still, the PhD students are not allotted to me. Perhaps there is a probability would be there the next year, because the next month there would be an examinations, and because of it's a big university, generally the invigilation duty is exempted to the associate professor and professors. They will not do the invigilation duty. That is the procedure. But I told them here, because their lack of staff, sir, it is go for 3 days, 4 days, 5 days. At the instance, time adjustment would be there. Anyway, that we will see that how best we can make it out. Because some of the people are asking me, sir, there is a LLM entrance examination is there, sir, and for that also you teach us. I don't know when would be the LLM examination.
It's in the notice. We have given the notice. We have filled the application form, sir, but the date is not yet released. I guess it's in July.
Okay. Because
July.
last time, no, not last time. Before last time, I dealt for the LLM examination for the
Okay.
prepared for the LLM examination students at the time. I think 2 years back. Let us see that how much the time it will be given to me to spare.
July 22nd is the date, sir.
Okay. So let me start with the LLM. When
Okay.
because
Okay, that
LLM
will be helpful to us, sir.
Yes, please.
Yes, that will be helpful to us.
Yeah. For LLM, when you start with the LLM, even some may cover in the JPJ, where JP, that is a judges examinations.
Yes, JCJ.
JPJ exams also. Because when I saw the JPJ exams, almost all the same, the method which you are following now.
Okay.
But certain variations would be there. They're more concentrated on the practicality.
Okay.
So that would be there. Okay, with that, I would like to wind up to today's class, and have a good day, and see you tomorrow with the Land Education Act. Please read and come to the class with the preparation, so that we can make the participatory class rather than the sermon class. Goodbye. Jai.